Hello, welcome to the Orthodontic Products Podcast. I'm your host, Alison Werner. In this episode, we're going to talk about how hidden lease provisions on your practice property could be draining your profits and putting your success and financial stability at risk. Many dental professionals unknowingly sign contracts with hidden provisions that restrict practice growth, complicate future sales, and limit strategic business flexibility. Understanding the nuanced language of commercial leases is not just a legal necessity, it's a critical business strategy for long-term success. Joining me to talk about this issue and to get some advice to help protect you is David Cohen, an attorney specializing in dental practice leases, who has seen practices and DSOs suffer setbacks due to poorly negotiated contracts. Cohen has extensive experience in representing individuals, mid and small-sized corporations in partnership and limited liability company law. He regularly counsels clients ranging from startup ventures and large companies to nonprofit charitable tax-exempt organizations and professional corporations. He has expertise in contract negotiation, review, and construction. He is chairman of Cohen Property Law Group, which has offices in Miami, Seattle, Philadelphia, Dallas, and Beverly Hills. David, thank you for joining me.
Thanks so much for having me. Looking forward to doing this.
Yeah. Okay. So to get started, can you talk about your experience working with dental professionals regarding commercial leasing?
Yeah, so we have a law firm that specializes really in helping dentists in all transactional business capacities, including practice transitions and so forth. And a huge element of a practice transition is the real estate. And most of the time, the real estate is going to be a lease.
Yeah.
From time to time, doctors will buy and sell the buildings for the practice, but most often there's a lease involved, whether it's with a third-party landlord that owns the building that's already leasing to the seller of the practice, or whether it's a seller that owns the building on their end. But either way, we're dealing with leases quite often. And so that's a huge component for us. We do over 300 transactions nationwide yearly. And I would say, the majority of them, I'd estimate probably 70%-ish, 75% have leases and are not building sales. So we're seeing leases across the country on a daily basis. And that's why Cohen Property Law Group is essential in the transition, because Cohen Property Law Group comes in from a real estate perspective on the transactions and brings its expertise to the deal from a real estate perspective. And we've seen all different types of leases. We've seen the mom and pop lease. We've seen the big institutional landlord lease at a shopping center.
Okay.
And these are all different types of leases that really need to be evaluated by an attorney. And, I say it, to the dentist, you wouldn't want someone working on your mouth that's not a dentist. And the same thing, that you don't want to sign a legal document without having a lawyer review it. And unfortunately, these leases can have significant consequences if not reviewed properly. And we see that all the time, whether it's a doctor coming to us and saying, hey, I signed this lease, didn't get an attorney, but I have this problem. Can you help me? And so we definitely see the mistakes all the time from not getting proper review. And I think the biggest thing that we see with doctors, that we tend to see, it's a trend, that because the practice is kind of the main event, so to speak, for these doctors, they don't, and I'm not saying everybody, I'm not generalizing, but most of these doctors legitimately view the lease as kind of like a throw-in. It's just like the way to close the loop on getting the deal going forward.
Yeah.
But they have to understand that the lease is critical, just in the same way that the practice part of the transaction is as well. So that kind of brings it full circle to answer your question, which is, how are we involved in these transactions from a leasing perspective? And we usually come in from the front end and help proactively the doctor avoid problems later on down the road.
So what are some of the most common hidden clauses in office lease agreements that orthodontists and other dental professionals overlook? And how can those then impact the long-term success of the practice?
Yeah, I mean, I think the biggest, and I'm just trying, taking the most extreme approach here to start with, but the biggest hidden provision that doctors don't see. And this can even happen if an attorney does review the document. This is how hidden this provision is.
Oh, okay.
From time to time. It can actually often be reviewed by an attorney and they just miss it. And that's why it's important to have a real estate specific attorney involved. But language that says the doctor has to share profits from the sale of their business. And we have seen that more and more over the last, I would say, 3 to 4 years than ever.
Huh.
And, I think, most of the time that language is in like a shopping center lease where they're used to having retail clients.
Okay.
And oftentimes there is a dynamic where the landlord will share in profits of the business with retail clients.
Okay.
But a dental office is not that way. And, I've seen the most extreme example of, we had a DSO deal in Hawaii, and the landlord was asking for over $1 million. It was a pretty big DSO sale, but they were asking for like $1.5 million from the sale because the lease had said that the tenant had to share profits from the sale with the landlord. And that actually was a pretty black and white provision, but you can see, so first of all, it was in black and white, but it's hidden in the sense that you would never expect that to be in a lease.
Yeah.
But that language can actually be very tricky and not as black and white. And you can easily gloss over it or not think that they're referring to you selling as a dentist.
You're just assuming
profits.
You're just assuming maybe this was a boilerplate contract and it was just left in.
Well, no, not necessarily. I think it's more in this. Well, it's possible, I guess, but maybe it's in there for a retail client and they just never took it out. But I think that lawyers for big institutional landlords have gotten very savvy at how they can draft the provision where it's not obvious that it looks like. Probably what I should have done is shared the language here visually on the podcast, just so you can kind of see what I'm talking about. But I mean, I think the most extreme example to answer the question of a hidden lease provision, whether it's hidden because you don't expect it or whether it's hidden because it's just not drafted in a way that's obvious, is language that says that the tenant has to share profits of their sale, their business, to the landlord. Now, not only is that a problem from the perspective of no tenant wants to share profits of the business with the landlord, nor do they expect to do so, at least a dental tenant.
Yeah.
But it also causes a problem because the buyer now, you're asking as a seller, you're asking the buyer of your practice to take on a lease with the landlord that looks like that, and they're not going to want to do that. So so these types of provisions can really restrict the marketability of the practice. And there are some institutional landlords that are kind of like take it or leave it, and maybe they have the leverage, but not always. And also, this is the type of provision that may be able to be negotiated from the beginning just because it's not a retail business.
Right.
And so I definitely think, that's the number one probably extreme example of what I've seen. And that can cripple a business because it can prohibit a doctor it can really make it prohibitive from them selling their practice. And then if they, not just from an economic standpoint for them, but they have to find someone who's willing to take that lease on, which is not likely to happen.
Yeah.
So, in the example that I gave you from the Hawaii deal, the buyer was a DSO, and they had to find a way to renegotiate that lease if they were going to take that on.
Okay.
So, long story short, that's the most extreme example.
Okay. What are some of the more common hidden clauses then?
More common hidden clauses would be, language that says that the tenant, for example, would have to return the premises to what they call white box condition, or to its original condition.
Yeah. Okay.
And so, like, let's say that the lease ends and the tenant doctor wants to leave, then they would be required to return the business or the premises to its original condition. That can be very costly and very expensive for a doctor. And so that's when you want to look out for and try to negotiate on the front end,
Okay.
so that you don't have that type of cost. Because if you're going to move to another premises, it's already probably going to be costing some money. I don't, you know, whether you're doing a startup and a build out, or whether you're buying another location, whatever it is, there's going to be a cost to that. And you have to underwrite into it what the cost would be to return the premises back to its original condition. So that's an example of one. Another example of one, that's important for doctors to understand, and this also can be written. This is kind of like a blatant one in a lot of cases, but from time to time it is not that obvious. It's assignment language. Assignment is probably the most important aspect of a lease for a doctor, because it's what allows them to sell their practice, essentially. As long as there's no other crazy clauses in there, like sharing the profits of the business upon sale, really the assignment language is the vehicle that's going to allow the doctor to sell the practice. Because when a doctor sells the practice, they are going to want to assign the current lease over to the buyer.
Right.
And so what does the language say for assignment? Now, a lot of times it's very obvious. I wouldn't call it hidden, but other times it's not as obvious, and it's a little more murky in terms of under what circumstances the doctor can assign the lease. Now, the provision is typically going to say assignment or assignment and subletting. But so that's obvious, but it's the language that's in there that can often be complicated, and, hidden things can be in there that could restrict a doctor from being able to assign. Now, all doctors would love for leases to say that the doctor can assign the lease at any time without the landlord's consent. But that's not realistic.
Right.
I mean, realistically, the landlord's going to need to consent to the assignment of the lease, just like if you, doctor, were out there was a landlord, you would want to know who's coming into your premises and approve of it, and that they have the credit to pay the rent and all that kind of stuff. But what you can have is language that says that the landlord can't unreasonably withhold or delay their consent. And that's really important and powerful language that I think is highly recommended to be in there. But there are other more complicated assignment provisions where it may say that the landlord will allow the assignment, but for instance, the tenant has to be at least equal to or a better credit than the doctor that's in there to begin with, which is not really that fair of a provision, because, I mean, it could be that the doctor credit that's in there is like far beyond what the landlord would need to be sufficient.
Right.
And maybe you have a younger buyer that just, there's no way they're going to have that type of credit that the selling doctor is going to have. And in fact, most of the time they don't. And then they might not qualify. So usually you can get around that by the seller just continuing to guarantee the lease, which they're not going to want to do. And then you get indemnification from the buyer. But yeah, I mean, there is some hidden language in the assignment clauses that can impact the doctor's ability to sell the practice. So that would be another one. The other one that I wanted to bring up that I think is really important is, from time to time, we will see relocation clauses in leases where usually these are more institutional type of landlords with maybe a shopping center type of lease. But we will often, if we see the language, we'll often see language that says that the landlord can relocate the tenant to another premises.
Oh, within the complex.
It could be within the complex. It could be not in the complex. Usually it typically would be in the complex, but so we've seen that, and that can be very difficult for a dental practice. A dental practice is just not set up or made to be moved. Not just because of the build out scenario, but also there's no way to transition the practice where, I shouldn't say no way, it's unlikely to be able to transition the practice to where you can not lose any production and just go from point A to point B and just be off and running, right? So there's going to be some loss of production during that time. And that can be very, very difficult. And even more so, we see some of these clauses either sometimes say that the landlord will not pay for the relocation cost, or that they will pay for the relocation cost, but you really come to find out after, running numbers and all that, that whatever they're offering is not nearly going to pay for what would be required in relocating. So what you don't want as a doctor is to be in a lease where the landlord has the relocation right and they can relocate you. You then have the burden of just the pain that is going to entail, but also you're going to lose money probably production wise during those days or during that transition. And you might be stuck with the cost of relocating, or at least some of the cost of relocating. And that can be very problematic as well. So I think, the hidden part of that, if we're talking about what's hidden, is, sometimes you'll see, oh, okay, well, they can relocate me, but they're going to pay for it all. Or they're going to pay the costs, right?
Right.
But you don't realize that actually what they're offering to pay is not enough.
Yeah.
And so that's something to look out for as well. Okay. So those are just kind of some examples of things that we're seeing in leases. And just to kind of like shout it for the mountaintops here to all the doctor listeners, these are things that can just make or break your practice.
Yeah.
And you would not think that, you always think of the clinical side or the business side of like buying or selling a practice. Mm-hmm. But the real estate and the lease are just incredibly important in these deals. And so it's just really important. I just gave you a few examples of many that are really could cripple a practice.
Well, I wanted to ask you, because leases will often include like maintenance, repair, replacement obligations that can also burden a tenant. So how can an orthodontist ensure that they're not taking kind of these excessive responsibilities for like a building's upkeep as well?
Yeah, I mean, that's a great question. And I think that the answer to that is that negotiating the maintenance, repairs, insurance, replacements, and all that, taxes, that's all typically part of the negotiation. Mm-hmm. And what I will say is that before entering a lease, particularly like for a startup where it's like an institutional lease, it's really important to have a letter of intent that's very thorough, that really is negotiated, and that you're not just handing to the lawyer signed and where now their lawyer's hands are tied. Mm-hmm. It's really important to have that, because these are the types of things that get negotiated in the deal. And, even in a triple net lease, which is a triple net lease is where the tenant is responsible to pay for those things, repairs, maintenance, taxes, insurance, and all that. There are certain areas that can still be negotiated where it doesn't have to necessarily be the most traditional of triple net leases that's out there, right? Like you can negotiate if you're a tenant on, let's say, the HVAC. The HVAC replacement or repair can be significantly expensive, mm-hmm. particularly the replacement. It could be 10 to 20K. Yeah. So, as a doctor, if you are able, even in a triple net lease, if you can negotiate the HVAC and say, hey, landlord, I'll maintain it, but if it needs to be replaced, you have to replace it. You own the place, and I haven't even necessarily been in this premises for the useful life of it. Yeah. And then, if they say no, then maybe you can negotiate the useful life and say, well, that you'll pay for the proportion of the useful life based on how long you've been in the premises, so that you're not getting killed on that. So like, these are just sort of like strategies that you would go through as a negotiation with your attorney on some of these expenses for maintenance and repairs and replacements and so forth.
What if an orthodontist is already locked into an unfavorable lease? What steps can they take to like renegotiate or mitigate some of those risks associated with these restrictive or kind of costly clauses?
Yeah, so it's really difficult to negotiate a lease once it's signed. Okay. Your best, and that's why it's so important to have legal counsel in on the front end, mm-hmm. so that you're not tied into something, because if the landlord's going to change a lease, just like for you as doctors, if you have a great lease, you don't want the landlord being able to just change that on you, right?
Yeah.
So the best way to negotiate the lease is leverage, and leverage is options. And understanding in the negotiation what the options are is a matter of sort of like probing and finding out how to get the landlord more of what they want. And if you can do that, then you may incentivize the landlord to be willing to change some things. For instance, if you are near a renewal of your lease, if you're already in it, but you have a renewal coming up, and let's say it's not the most marketable of properties, where they don't have 10 people lined up that'll just take the property if it's not you,
Mm-hmm.
you may be able to negotiate and say, hey, landlord, we got this renewal coming up. I'll renew and give you more stability here with the tenant long term. In exchange for that, here's some things that I want to renegotiate or want to negotiate. So that would be one example, but that example would only be applicable in a scenario where the landlord, through your probing and trying to understand how to get the landlord more of what they want, is if you understand that they want someone more long term. If the landlord doesn't have to have you and they can easily lease it up in a second, then it doesn't necessarily give them more of what they want to get them more time. You'll have to look for something else. But the way to find out something else is probing and better understanding and listening to what is going to be important for the landlord. And you typically would do that through your lawyers, but it's finding out how to get more leverage, how to incentivize the landlord to want to agree to change some things in exchange for something else. So that would be one example that I just gave, which would be giving them more time on the lease in exchange for maybe being able to negotiate some things.
So what's your takeaway advice for someone who is looking at signing a lease? When should they be pulling a lawyer in? What should they be looking for? What's kind of your takeaway advice here?
I think the takeaway advice is to get legal counsel involved as soon as you possibly can, once you've identified the property.
Mm-hmm.
And whether that means if you're in a startup, before the letter of intent phase, which I mentioned is really important, or if you're like buying a practice, then it's just organically going to be part of the process. But it's important to put as much weight and importance in that lease portion as you do the practice. From time to time, we'll get clients that say, hey, help us with the practice side, but we're not going to worry about the lease. Or I have a lot of, I have a broker that, is helping me, which I'm not putting down brokers. Brokers are very important. Brokers aren't lawyers. And so it's a different type of review. And that's why it's important to have an attorney involved there as well. Okay. So I think the earlier you can get an attorney involved, the better. For us, we charge flat fees. So we're not just trying to run a bill on a doctor. I know there's some other law firms that do that as well too. Yeah. So, I'm not just saying this so we can run bills for a longer period of time. It's just not how we operate. Yeah. I'm just saying it because our hands are tied if a doctor signs a letter of intent and now there's not much we can do.
Right. Exactly. Well, David, thank you so much for joining me. It's been a pleasure. If someone wants to get in contact with you, what's the best way to find out more information about your property, your law firm? Sorry.
Yeah, that's great. The best way to get in touch would be via email. And my email is david@cohenpropertylaw.com. So David at COHENLAWPROPERTYLAW.com.
Great.
That's kind of the email we use if it's lease related for the property. But then, for the practice sale, we use the other email typically, which is David@CohenLawFirmPLLC.com.
Okay, great. Well, thank you again. It's been a pleasure to talk to you, and I really appreciate your expertise.
Yeah, it's been a pleasure to be here. I really appreciate you having me.
Great. Thanks. As always, thank you for joining us. Be sure to subscribe to the Orthodontic Products Podcast to keep up with the latest episodes. And be sure to check out orthodonticproductsonline.com to keep up with the latest industry news. Until next time, take care.